Everybody, I'm Randy Saunders. Unfortunately, I don't have any good underwear stories to follow up on, so I'll try to do my best. I know it's getting late in the afternoon. Just, I guess, a little bit about kind of the perspective that I go in with. I'm a defense attorney. I defend servicers, financial institutions, and so when I'm speaking today, that's kind of where I'm coming from. And I'm going to talk about notice of right to cure in 46A 5108. And we're coming up on the 2-year anniversary or birthday. And when I started looking at this, I got thinking, as a father of a 6-year-old, 4-year-old, and 2-year-old, I thought with the 2-year-old birthday coming up, we may be on the verge of getting into the terrible twos with this, because we've had a year where we've kind of tried to figure out and see where some of the issues and problems were. We've seen a little bit of case law start to come out, but there's still several, I think, questions, especially when you get into the class action realm, that are going to take some time and some figuring out. But just to take a step back, just in case you're not familiar with 46A 5108, again, looking at Article 6 of the West Virginia Consumer Credit Protection Act, there was always a notice of right to cure obligation. In July of 2017, the statute went into effect, requiring a notice of right to cure if you were bringing a claim under Article 2, 3, or 4 as well. Specifically required West Virginia consumers to send a written notice of right to cure to a creditor or debt collector prior to instituting a new action. After receipt, the debt collector or creditor would have 45 days to send a cure offer. Unless there was an action pending, then you'd have 20. And as we're going to talk about in a little bit, some of those deadlines have caused some confusion as well. And is it a new case or is it a new claim? Is this a 45-day deadline or a 20-day deadline? If accepted and performed, then you had a complete bar if future litigation attempted to allege those same claims. What's interesting, I think, getting away just from the statutory construct and some of the case law that's out there, is taking a step back and look at the practical with regard to this statute. The overriding goal, I think, was to allow creditors and consumers to try to come together and avoid costly and time-consuming litigation. And I would say at this point, I don't think that's happening. And I think there's a couple reasons for that. So I want to sidestep, and I'm going to come back and I'm going to talk about Henry and Adkins and a little bit of the case law. But I think that from the outset, and this is probably, I don't know if any of y'all listen to podcasts, but I've been listening to the hardcore history on that was on World War I, and so it got me thinking that when you look at this cure offer, it can kind of have two effects. It can be kind of a peace offering, or it can be kind of the initial attack or offensive. And the significance, I think, of with how counsel acts and how the clients act. And so when I look at the clients that I have, they're institutional clients that I've had for years, and then there'll be new clients that aren't familiar with West Virginia, and that's always fun because you have to explain stuff to them 100 times, and they can't believe that this and that, and so it goes on for a while. But what's interesting is a lot of times they'll have received the notice of right to cure, and they'll have reached out and talked to opposing counsel and helped you out a lot. And so by the time you get in the game, they're opposing counsel's ahead. They've already talked to your client, and your client's treating it like a QWR, and they had no understanding of what 46A 5108 is, what the benefits were, of responding. And so when you're in that situation, I think that as you're trying, at least from defense counsel, from my perspective, that's one of the first things I try to do is talk to the clients and help them understand that, when you receive this, it's not a QWR, and there is a benefit to looking at this, and we have a short time frame to do it. Um, the other thing that I think, and what's interesting is when you look around the room and we talk about cases, like the majority of the cases that we talked about, both sides are in this room. Like defense counsel and plaintiff's counsel are inside this room. You know, and so our bar, when it's in this practice area, is a pretty close knit group. And you know, it's very easy, I think, to reach out, to call, and to try to have those conversations at the outset with opposing counsel, and I think that helps the effectiveness of the notice of right to cure. And I think even from a perspective of saying, all right, if you've got an individual claim and the notice of right to cure is garbage, and you can't tell, and your client actually is interested in having some discussions, you know, you pick up the phone, you call, and see if you can get a better notice of claim. Say, look, we can go down the road, we can play the game, I can send a letter back, because I'm going to get into this in a second, but we've kind of taken the position to treat what we think are deficient notices of right to cure the same way we would treat notice of claim and certificate of merit under Hinchman, and send out a letter, you know, and say, hey, we think this is deficient. We don't think you've complied with the statute. But sorry, I shouldn't have taken that left turn there, and I lost my train of thought. But I think reaching out to opposing counsel and trying to have those conversations, if we're actually trying to get back to the goal, and in trying to have those early conversations to see if resolution is possible, is important. The other thing is when you get the notice of right to cure, and at the bottom there's the little language that, you know, it talks about how it's also effective as to similarly situated individuals, or and you know they're trying to incorporate the class. I have yet to have anyone accept a cure offer for the class representative. You know, so again, you know that those notices of right to cure are more initial attacks or offensive. You know, and you can go back to your client. You can say, hey, we can make a cure offer here, but we're probably wasting our time. You know, obviously this is setting up for a class action. They're not going to take a cure offer and lose their class rep. But I did want to talk about a few cases, and what's interesting in the most recent case, Adkins, Judge Berger actually referenced the fact that there's relatively little case law that's out there at this point. But I think two cases that are worth you know, taking a look at, and I noticed that the speakers have talked about a lot of cases today, and there seems to be one constant problem, and that's Jonathan Marshall. But it's a love-hate relationship, you know, because the first one is Henry, and it's interesting. The plaintiff filed CCPA action and decided that because they had received a payoff quote and they felt there were some issues, some additional claims, filed a motion for leave to file an amended complaint. They, instead of sending a notice of right to cure before filing the motion for leave, they sent their notice of right to cure with the motion for leave. And so what ended up happening, the defendants argued that prior to filing the action, the plaintiff was required to give notice and then give them 20 days. The plaintiff said, look, the action already existed. We complied with the statute because we sent the notice contemporaneously with our motion for leave, and we haven't filed a new complaint. We only filed a motion to amend, and so until that's granted and the new complaint is actually filed, they still have the time. And it just so happened that actually defense counsel did make a cure offer in the interim period. It's interesting, I think, here because with the motion for leave to amend the complaint was going to go from an individual claim to a class. And so, you know, I think that probably escalated the issue and the fight. But it's I think this is a West Virginia, I'm sorry, it's a United States District Court, Judge Chambers. And I think it's illustrative of how the court is looking at the time frames and is going to treat the issues moving forward. After that point, this was, I guess, maybe just a few months later, the defendant moved again to dismiss and then moved to disperse funds into the court. The defendant had made a cure offer of $5,000 based on one violation. Interesting fact again here is that the plaintiff again would be the class rep. And so plaintiffs did not accept the offer. The defendant, again, filed the motion to disperse the funds in, and a motion to dismiss only the CCPA account. The court actually initially entered an order granting it, and then plaintiffs sought reconsideration, and the court eventually denied it. And again, what we're seeing is that the court, when we're dealing with a few cases we have, looking for other analogous case law that might be out there. And here the court looked at Rule 68 for offers of judgment, and basically looking to say, all right, the defendant was saying, I've offered $5,000, that's all, that they can only get $1,000. And so, I mean, we should be able to basically disperse the funds into the court, and we're done. Judge Chambers, looking at some case law on the offer of judgment, case law that was out there, said, look, these are uncapped, unspecified damages, and specifically referring to the actual damages that were pled. And said that we're early in discovery, there hasn't been an evidentiary hearing, there's a potential, even though it might be slight, that they can recover over $5,000. So we're not going to allow it to be dismissed at this point. The practical effect of this, again, I think just getting away from the ruling, is that when clients see this, it's this kind of ruling that makes my clients more apprehensive to engage in these discussions. And I think that this probably forecloses a lot of negotiations or discussions anytime they see a notice of right to cure that has any type of class reference in it. And quite frankly, again, if you have that call with opposing counsel, that may be fine. I mean, everybody may just be going through the motions, but again, that makes the whole notice of right to cure, the whole statute, insignificant at that point. And I think somebody was mentioning collection of debt beyond the statute of limitations earlier. Adkins, and this is another Jonathan's cases. Again, class action, alleged attempt to collect a debt beyond statute of limitations. Defendant argued that the notice and cure letter were inadequate. This is the one where Judge Berger basically came back and said, look, there isn't a lot of case law that's out here. The court found that the pre-suit requirement is not jurisdictional in nature, and this is where Judge Berger looks back at Hinchman. And when we're looking at similar pre-suit requirements, I think Hinchman gives us a pretty good starting point. And what Judge Berger says, although their legal theory appears to have shifted during the course of litigation, the factual substance of the claims remains the same. The notice letter contains sufficient information to alert the defendant to any alleged deficiency in its communication with West Virginia consumers regarding debt outside of statute of limitations. So again, Judge Berger is basically saying, as long as your notice of right to cure kind of outlines the factual, even if the legal theory shifts, that's enough. It's enough to start communications. And as at least in federal court, it's not going to be enough to make a determination that it was insufficient under the statute. Um, and got my notes out of order here. So again, talking about the practical effects. When you look and you say, okay, what is my client on the defense side? What are they looking for? What do they want? The first thing would be not to get one, but you guys are probably not going to do it. So you know, if there are issues, you're probably going to send the notice of right to cure. I think what they're looking for is something that provides enough specificity and demonstrates that you actually are interested in having those pre-suit negotiations. Again, you know, the questions come a lot from defense side and from the plaintiff's bar, who ask, are you even settling any of these? And it's really dictated by our conduct as plaintiff and defense counsel. Are we taking this seriously? Are we putting the time in? Are you telegraphing that you actually do want to have these conversations? And if you do, and you have a client that understands the significance of the statute, my experience has been, yes, they are willing to sit down and look at this and make cure offers. And so, you know, from the plaintiff's perspective, setting aside for a minute class actions, if it's an individual claim and they are interested in resolving it, I think taking the time and drafting a notice of right to cure letter that provides enough clarity and enough specificity so that the defendants can look at it and you know, be in a position to sit down and negotiate is important. The last thing I want to say before I wrap up is that there are a couple questions that are big in my mind as we reach the 2-year-old birthday. And I think that these are going to be the problems that are going to have to be addressed. And really, the vast majority of them revolve around class actions. And so the question being the effect of the statute will have on individual claims for potential class reps. Can the consumer demand a settlement on behalf of a class prior to class cert? What's the effect of a rejected cure offer to a class rep's claim if he or she does not individually recover a judgment above the individual cure offer amount? And are creditors, debtors required to address potential class claims in cure offer? And so I think when we look at, honestly, I think when this was drafted and this was implemented, it was looking at individual claims. And Sandy you may, because I know you were there, you know, I think when we get into the class, you know, I'm not sure if all of that and the implications on the class actions were kind of fully considered. But anyway, I'm already past my time, but I do think that the big frontier in there is going to be the class action issues.